Former President Jacob Zuma has been granted leave to appeal a High Court order setting aside his medical parole. His lawyers say he suffers from a chronic and progressive condition. Zuma spending less than 2 months in prison for being in contempt of court after he refused to appear at the State Capture Commission of Inquiry. The High Court sitting in Pretoria ruling that his parole was unlawful and ordered that he should return to jail. Newzroom Afrika's Malungelo Booi has more.
Former President Jacob Zuma will head to the Supreme Court of Appeal to defend his release on medical parole. His lawyers successfully argued against last week's court ruling that his release from prison was unlawful. In September, the former president was granted a medical parole by Correctional Services. That was 2 months into his 15-month sentence for contempt of court. The DA, Helen Suzman Foundation and AfriForum took the matter to court, arguing Zuma did not meet the requirements of the medical parole. In their leave to appeal last week's court ruling, Zuma's lawyers insist Correctional Services was not wrong in releasing him.
If there is a specific section that says the National Commissioner and specifically excludes all these other people, excludes the minister, excludes the parole board, excludes everyone, may grant parole for prisoners who are serving a sentence of less than 24 months. Then that must be given effect to. Otherwise, those words are meaningless. It means that section is just there for decoration. Because otherwise, we should just all go to Section 79.
The Correctional Services Department, another applicant in the matter, also defended its decision.
In relation to medical parole, my lord, there are no times for qualification for medical parole. What is only required of an inmate or an offender is that he must suffer, the kind of illness. He must be terminally ill, or that he must be incapacitated in such a manner that he's not able to perform his daily activities. That's all that is required. While the time frames that are required for ordinary parole, that is not required in relations to medical parole. So he can be determined at any time.
Mpahlele also sought to explain the role of the Medical Parole Advisory Board.
This is the role of the Medical Parole and Advisory Board. It only provides an independent medical report to the National Commissioner in respect of this matter. It doesn't, as your Lordship has ruled, makes a determination or a prognosis, and the fact that your Lordship ruled that such a recommendation is final and binding, we submit that, my Lord, that is a misdirection.
But one of the lawyers for the opposing parties maintains that the former president cannot be treated differently from other offenders.
The court, with respect, should not substitute legal reasoning, which is what your judgment contains, for unwarranted sympathy for the position in which Mr. President or Mr. Zuma finds himself. The position he finds himself in, Justice, is one of his own making.
But in the end, it was Zuma who came out victorious.
In my view, this matter merit the Supreme Court of Appeal's attention to bring certainty in the correct interpretation and application of these provisions.
The judge also noted that he was of the opinion that there is a reasonable possibility that another court could come to a different conclusion. For Newzroom Afrika on Channel 405, I'm Malungelo Booi in Johannesburg.